Hello, everyone. My name is Kay Van Way. I'm a medical malpractice attorney and a patient safety advocate. I'm joined today with my friends and my colleagues. We have with us Bob Oshel. Bob is a former associate director at the National Practitioner Data Bank. We have Dr. Robert Henderson, a board certified spine surgeon. We have Ann Roberts, a vice president at a major medical institution, hospital system in New England. Her actual title, I think, is Vice President of Medical Staff Services. And we have Dr. Martin Lazar, a board certified neurosurgeon. Today, my friends gathered up. I don't know if it was for kind of a therapy session or to discuss something that came across my news feed a day or so ago about this bingo doctor. Apparently, there was a doctor in Colorado who was an anesthesiologist who was giving anesthesia, sedating patients. In this instance, a 57-year-old man who was undergoing surgery for cataracts. Apparently, based upon the little bit of information we have about the case, we know this occurred at an outpatient surgery center. We believe that the alarms were turned off. We believe that the anesthesiologist and perhaps the surgeon were distracted because they were playing a game of music bingo where they were playing songs and then they had to guess the name of the song and then fill in the squares so they could make a bingo. We also believe that likely they did not realize that the patient was declining until the patient was in full-on cardiac and respiratory arrest. The patient subsequently expired. So what we wanted to do today is get together and break this case down based upon what we do know, because part of why this is so upsetting to us is that we all became friends and colleagues through our work on the Dr. Death cases. It's been 12 years ago, I believe. And since that time, we've been advocating to fix the problems that existed long before we ever had a Dr. Death and the problems that continue to exist that put patients at risk. So we're really going to focus on some of the things that are recurring problems with our healthcare system that we believe need to be changed. So it's my privilege to call these people my friends, and they are each of them true experts in their fields. And I'm just privileged to be able to try to stay in their depth and keep up with their brilliance. So, without any further ado, where I wanted to start was the fact that this was such a seemingly simple procedure. Like anybody would not think, any layperson would not think that you could go in for a simple, 10-minute cataract surgery and not come out alive. So, I'm wondering, whoever wants to jump in here, Dr. Lazar or Dr. Henderson probably, what what can you tell us about the type of procedure this would be from the standpoint of sedation, how long it would take, what type of monitoring equipment there should have been so that the anesthesiologist would have realized the patient was getting into trouble before he did, and just kind of walk us through that, if you would.
I can start. Um, be done under local anesthesia. It's usually a choice of the surgeon and the patient together, but it also can be done under conscious sedation, where the patient actually is awake but sedated. In this case, my understanding is that the patient uh, was anesthetized. Um, in all cases, the patient has to be monitored no matter what form of anesthetic is being used, including under local anesthesia. The minimum is blood pressure, EKG, and those pieces of equipment have, as part of the monitoring system, they have alarms, and those alarms are usually audio. Some alarms are audio and visual. Those parameters that are set on the alarms are set by the anesthesiologists or technicians who service the equipment, but they can be turned off. And apparently, in this case, that's what happened. They were turned off.
And can you talk to us, Dr. Henderson, maybe about a little bit more about the alarms? My understanding is that some of the alarms that are on these monitoring systems are designed as early warning signs so that prior to the patient, having a cardiovascular collapse, trends are being noticed so that the anesthesiologist can intervene before it becomes a catastrophe.
Yeah, correct. I mean, the parameters can be set. I mean, you have, as Dr. Lazar was mentioning, multiple different signs, vital signs you can monitor. Blood pressure is one. You can set alarms on the blood pressure. If it goes too high, you get the alarm. If it goes too low, you set the alarm. You set the frequency that blood pressure is taken, and that would depend on the length of the procedure. It would depend on the type of anesthesia that was being utilized. A pulse oximetry device, which is a little device you normally put on a digit, a finger or a toe or an ear, measures the amount of oxygen that's circulating in your system. Actually, the O2 saturation of your hemoglobin tells you how much oxygen you have and if you're perfusing in your lungs correctly or not. And you set those parameters, not for being too high normally, but for being too low. That's an important one. Pulse rate is obviously another one that you want to know, is it too high? Is it too low? EKG even has parameters on it that can be set for erratic rhythms, like you can pick up an atrial fibrillation or premature ventricular contractions that tell you that something else is, whether it's chemical, something they've been given, or whether it's O2 levels or CO2 levels that are affecting the acidity of the blood in causing abnormal physiology to occur. They even have a monitor for respiratory rate, how many times per minute you're breathing, and you can set those alarms. So there's plenty of alarms that can be set. The alarms are auditory and they're visual. And they're visual in the sense that they're colored on the screen normally, and they'll blink. And so a red line will come up, or yellow or green line, and can be visualized if somebody's paying attention. But you got to be paying attention, and you got to have the alarms turned up. And in this case, it was our understanding the auditory alarms were turned completely down, and maybe no one was looking at the screens to see the visual alarms. And the other thing that seemed to be a little unusual in this case, although there can be extenuating circumstances, is why the level of sedation would have been so heavy as for the person to have literally lost consciousness. Mm-hmm. and not be able to participate in the conversation in the room, or be responsive to queries as to the status of the patient during the procedure. Because normally this is done, this type of eye surgery is done with local anesthesia and then some light level of sedation or relaxation.
But in this case, obviously, the level of sedation was quite deep.
Seemed to be.
Does
And
that
there's
raise
really a question as to whether or not that was necessary or not.
Yeah, that was going to be my question. It does raise that question. Of course, we don't know enough to speculate about it, but we certainly can draw parallels with other situations we see where unnecessary sedation or an unnecessary depth of sedation is given unnecessarily. I know that's redundant. I said unnecessary and then unnecessarily, but we can certainly draw parallels to other situations where unnecessary sedation is given, not because the patient needs it, but because it's a higher rate of reimbursement. I've certainly seen that in my cases, and I know some of you all may as well. You know, the thing about the early warning system, so to speak, with alarms and the technology that we have available today, something that I've heard is that in the hands of a competent and attentive anesthesiologist, anesthesia is actually in today's day and age very safe. And that if you were going to get into some respiratory or issues or cardiac issues, they have the medicines, they have the tools to address these things. And that's part of the beauty of the early warning systems, is the ability to address it early and reverse it. Is that generally true?
Yes.
Yeah, absolutely.
So this may sound silly, and I'm asking it in a silly way because we all know the answer. But what's the problem with a doctor, an anesthesiologist, and a surgeon playing music bingo during any kind of surgical procedure?
Their attention needs to be on the patient, obviously.
Right. Well, I'm going to play devil's advocate here. I think, as many cases as I've handled, I can almost tell you what they would say to defend themselves, which would be, we've done it hundreds of, if not thousands of times before, and it's never been a problem. And we can multitask. We can play bingo. We can play music bingo game and do our jobs competently. What would you have to say to that?
I'd say then they violated the standard of care the hundreds of times that they've done it in the past, because that just shows a pattern of not putting patient safety first. And so I think it would actually strengthen the argument for your case, in a malpractice case, to say, well, then, if it's your habit and a pattern, then that just shows how much disregard you have for patient safety.
I have
for some reason, it made me think of a corollary to that, of the person riding their motorcycle for months or years without a helmet. And I've never had any trouble.
Yep.
Until today, when I crashed and got my head injury and became an organ donor.
Right. Yeah. So, Anne, from your vantage point in hospital administration, whose job would it be to report to doctors who were so clearly doing something so dangerous?
Well, ultimately, if it was in a hospital setting, it's the medical staff's responsibility to hold each other accountable, to make appropriate reports. But you typically have administrators and attorneys that are partnering with the medical staff to appropriately report things that are required. For example, in the system where I work, I'm the point person to file reports with the data bank. Our legal team files reports with the state board. And so, but it's in partnership and collaboration with the physician leaders who are responsible for taking any type of disciplinary action that would be reportable. And so in an ASC, in this case, you would have department administrators, a corporate office who would be responsible for participating in investigation of any safety events and identifying if there's any action that was reportable. I think Bob can chime in regards to a process in an ambulatory surgery center that they are required to report. They have to have a peer review process in place to participate in the data bank. And I can't imagine any type of ambulatory surgery center that does not have peer review in place. At least they absolutely should.
Yeah, Anne is absolutely correct. If they have a peer review process, can take peer-reviewed actions against physicians or other people on the medical staff of the facility, then they have to report if they take a reportable action. If they terminate someone's privileges, if they suspend them for more than 30 days, if the person resigns while under investigation or to avoid an investigation, they have to report to the National Practitioner Data Bank. And then that information would be available to other hospitals, other surgical centers, to licensing boards where the physicians or the others may seek a license or continue to have a license. So, it's a system that's designed to make sure that someone can't move from one facility where they got in trouble to another facility or another state and get licensed or practice without the new facility or new state knowing that they had a problem where they were previously.
And I think one of the things our group has always talked about the workarounds with the data bank and the loopholes. And I think, and I'm just going to guess and speculate here that for ASCs, they probably use the loophole on the employment side. And so one of the gaps in the data bank is that if you take action under the HR and employment side, it's not reportable to the data bank versus restricting somebody's privileges or allowing them to resign their privileges while under investigation. If in an ASC, I think primarily when we don't see a lot of reporting, it's likely that they're taking action on the employment side.
Yeah, if there was an employee of the facility rather than someone who's just on the medical staff and privileged to practice there, they could do it that way and avoid reporting the physician. And that's something they would typically like to do, is avoid having to report.
I think one thing you said, Anne, if they had a peer review process, and we don't know if if they sought or received any kind of certification from like the AAASC. I never can get it, American Association of Ambulatory Surgery Centers. And so unlike a hospital, they would not have been required to have had any kind of a peer review committee, correct? Or a formal peer review process.
Well, I think in a situation like this, if they're not accredited, let's put that aside. If they're accredited, it depends on the accrediting body, but no, I would assume almost all, including the AAAC, does have a level of requirement for peer review. If they are not accredited, then they are at the whim of the owners. In this case, it was a joint venture, with physicians, but also, the agency or the company, the corporation that owned them. You'd have to look at, okay, they owned many, many practices. What are their guidelines for each practice in regards to evaluating and addressing individual practitioner performance concerns? The performance concerns is the entire team, is the entire surgery center. And so even if they're not accredited, then something that's a joint venture, they still should have something in place. Whether they do or not, of course, is the question, but they should.
Well, I think, the other thing that I would say is culture of safety. And it doesn't sound like this facility had a culture of safety. We also know that the bingo playing anesthesiologist was also the medical director. So in practical terms, is it really realistic to think that, a young surgical assistant or a young nurse is going to report, a doctor, especially if the doctor's the boss? Who are they supposed to report to if the offending person, the dangerous person, is also the boss?
Especially in
That's
a small organization like this.
Mm-hmm.
that's
So
the issue.
that,
Yeah, and we go all the way back to, well, is a report taken seriously, or does it go anywhere once it does it just go into file 13 after you put it through the shredder, uh, or is it acted upon anyway? And we know for a fact that at best 50% of hospitals in the United States have, in the last, what is it, Bob, 30 years or so?
Yeah, since 1990.
Yeah, since we've had the data bank, have reported
Never
even
reported.
one physician violation or finding. So compliancy is a real problem, and the peer review is a real problem, particularly in the smaller sized hospitals, or all ASCs are small. There's only a limited number of physicians on staff. And if you're going to refer an anesthesia behavior or outcome problem to anesthesia, well, turns out they're probably in the same group. So you're not getting a totally objective, response, interpretation. And that may be true for the surgical groups too. Or it may be that it's the major player in your surgery center, and if he gets hurt, the whole surgery center goes down. And profit wise, a lot of surgery centers are owned, or at least partially owned, by physicians,
The
which is
incentives,
not a bad thing. It's just that's the reality of it.
and that creates a situation where the incentives are not to take action, not to report.
Good.
right.
Good.
Yeah. That's right. If you're a part owner and an owner of the facility, it's going to be very, very hard to take action against the ownership. Um, yeah. Well, it is the obligation of someone, no matter who they are, if they're the radiology tech, whoever they are. If you see something, say something. And, I have to think about an analogy with, a jumbo jetliner. And let's say the flight attendant comes into the cockpit and sees the pilot and the co-pilot playing music bingo game or whatever, and they've turned off all the alarms because they don't want to be distracted. They want to hear the music. They don't want to hear the alarms. It's a whole different matter, because in that situation, the flight attendant is like, hey, my life is on the line here. I've got to do something. The incentives are different in healthcare, because in a bad culture facility, the incentive is the opposite. It's like, well, I got kids to feed, I got the mortgage to pay, I need this job, and I don't want to become persona non grata. It's not my place. I'm not going to say anything. I mean, what do you all have to say about that?
Well, that's exactly right. The pilot, the co-pilot, everybody on the plane goes down with the plane. But when there's a major malpractice problem with the case, the physician and the nurses and the anesthesiologist and so on aren't dying with the patient. So it's a different incentive, like you said.
My response would be, I don't want to be on that plane. But I would say, absolutely. I mean, you're correct. A tech, a nurse, or anybody in that room, they have bills to pay. They have other, they want to be able to, they have to be able to take care of their families and their bills and so forth. They need their paycheck. And so they have more of an incentive to not say something, or that might, somehow jeopardize their employment there.
Right.
And that
Well,
brings up one of the issues. We talk about compliancy with reporting, whether it's local in where you're employed or all the way up to the database. There's no penalty other than your conscience for not reporting.
Right.
And sometimes there's ramifications that are bad from reporting. So the incentives are backwards. And the other thing that I think we're missing, I think we have systems set up to help inform the public, which is what this is all meant to do, to help inform the public to be more confident that their physicians are competent and skilled and haven't had adverse circumstances occur on a continuous basis. But the only way to make this system work is if somehow we can get penalties ascribed to non-compliance.
Yeah, that's an important point, because the data bank theoretically has penalties for non-reporting. For hospitals or for anybody, though, the data bank will write the entity that was supposed to file a report, at least they think was supposed to file a report, and ask them, why didn't you file a report in this circumstance? And historically, they do that. Every time they've done it, they've either gotten a report late, but they've gotten a report, or they've gotten a reasonable explanation, well, why this wasn't actually reportable. So, there's a penalty that's never been assessed for non-reporting. And, I don't think it ever will be for non-reporting under the way the law is written, and the data bank's philosophy that we'd rather have a report late than not have a report at all. So
you're still only getting it from 50%
absolutely
or less of the hospital.
And some of that is literally failure to report something that should have been reported. Some of that, I think, is failure to take actions that should have been taken. The law says if you suspend somebody for 30 days, less than 30 days, there's no report. If you suspend them for longer, there will be a report. So what do you do? Well, if you've got somebody that, you want to keep on your staff, you've still got to take some action. You're not going to suspend them for more than 30 days. There's no report because there wasn't a reportable action. And, there are loopholes. They can, if somebody under the table, they say, look, we're going to terminate your privileges at the end of this investigation. But if you agree to resign the day after the investigation is over, and we will then terminate the investigation without taking any action, well, no action was taken. The person resigns. There's no report to the data bank. And the next hospital or the next licensing board never knows that this person, was a real problem where he had been practicing. So there are loopholes, and the system needs to be improved. The other thing Dr. Henderson mentioned was, that we need to, these are methods to protect the public. Well, that means the public is relying on hospitals to do the right thing in reporting, and also licensing boards to take action when actions ought to be taken. And both of those are kind of questionable. Plus, the public has no access to this data by law. So the public can't look out for themselves. Even if a report's filed, you or I or any member of the public can't find out about it. And we rely on hospitals to do the right thing in using that information, or licensing boards to do the right thing in using that information. And in fact, we can't. I mean, this person, the bingo doctor, was licensed later in Oregon. We don't know for sure if Oregon knew about it or not. Oregon probably could have found out if it wanted to, and it should have been on the application. But the people in Oregon weren't protected by the system in this case at all.
Well, if I understand the facts, he was later charged by the Oregon State Board for misrepresentation on his application. So, from what I can tell, it doesn't look like he was transparent in regards to what he disclosed to them.
Right.
Yeah.
When I was at the data bank, we did a study of whether or not people who received data bank reports received new information on those reports, information they'd never heard of from any other source, including the applicant's application. And we found that 9% of the time, the data bank provided information that the reviewing entity had never heard of any other way. That should never happen because there's nothing in the data bank that's not required on applications for licensure or clinical privileges. So, the data bank's a backup to make sure they get information honestly on applications. And clearly that's not always happening.
You
It didn't
know,
happen in this case.
right.
But, and what was the penalty the Oregon board assessed in this case? Was it a $5,000 fine, I think?
I think that's accurate. And then, like, shortly after, when they found out the details in Colorado, his license was changed to retired. But I don't recall exactly what the penalty was. I know that one thing that, Kay and I have discussed, this group has, Michelle, if she was here, Sugar, was the questions on the application and how detailed are those questions, specifically in healthcare systems, hospitals, ambulatory surgery centers, when they are getting a application, how detailed are the questions that are being asked of the applicant? Is there, wiggle room in the question, and so that they can say, well, I answered the question honestly in the way that you worded the question. And so how the question is phrased is really important as well. You would think, or hope anyway, that a state licensing board's questions on their licensing application was comprehensive enough as a catch-all, but you just never know.
Right. Well, I think, as we all know and have discussed many, many times, the entire point of mandatory reporting to the data bank, the entire point of having the data bank is to prevent dangerous doctors from moving from facility to facility or state to state. And in this case, that's exactly what happened, is that he moved to another state with an apparent clean slate. And Oregon is in the majority of states in the nation who allow the code of honor. And the data bank allows hospitals to have the code of honor. Like, even though the data bank knows that about half of hospitals have never reported a dangerous doctor one single time, they still allow them to go by the honor system, even though many of them have proven themselves to be not honorable. Medical boards, most of them still allow doctors to self-report and be the Boy Scout or the Girl Scout, even though it's been proven that they oftentimes are not. So Texas, to its credit, and I'm not really known for giving my home state of Texas a lot of credit when it comes to patient safety, but the Texas legislature did pass a law addressing this issue. It was initiated by what I call a young investigative reporter, Matt Grant, at KXAN down in Austin. And he and his colleague did, Dalton Huey, I think was his name, did an in-depth investigation. And what they found is that, guess what? Newsflash, some doctors were not honest when they applied for privileges in Texas, or they applied for renewal of their license. And in some cases, it was not just a minor thing. There were doctors that had huge problems in other states, but they said, no, no problem, and they were allowed into Texas. Similar to what happened with the bingo doctor going to Oregon. And so Texas now required the Texas Medical Board to enroll every physician in a continuous query. And so I would like for Bob to talk a little bit about what continuous query is and the positive effect that would have on, patient safety in general.
Well, continuous query is essentially a system where you enroll all of your licensees or whoever you want to enroll, but ideally, as Texas did, all of your licensees and all your new applicants with the data bank. And then anytime the data bank receives a new report about that physician or that nurse or whoever you've enrolled, you get that report immediately. Otherwise, if you're not enrolled in continuous query, you have to actively submit a query to get the information on that person. Now, hospitals are required to query the data bank once every 2 years. Now, they can enroll in continuous query, and that solves the 2-year requirement. Licensing boards, however, are not required by law to query the data bank. They're required to report, but they're not required to query. So Texas is now requiring that the licensing board query the data bank. New Jersey has recently done the same thing. Texas has been requiring that for all of their licensees for probably 20 years or more. But the other states tend to query the data bank pretty rarely. And so they're missing a lot of cases like this. Like, assuming that the surgery center involved here had taken action, or that there had been a malpractice payment made for this, the bingo doctor, that would have been in the data bank, and Oregon would have found out about it, whether the physician reported it on the application for licensure or not. Otherwise, if they don't query the data bank, they've got to rely on the physician being honest. And we know that the ones with problems to hide the problems.
Right. Yeah.
And one thing I would add to that, we talked about the employment loophole with the data bank earlier. Moving to another state, if an organization's verifying employment, the employer typically only verified states that they were employed there. It's very rare that you get an employment verification that tells you, was somebody terminated, did they have disciplinary action, and so forth. And so, one could stand to reason that when he applied for a license in Oregon, if they tried to verify his prior employment, they received dates that he was employed there versus this individual had disciplinary or corrective action, or he was asked to leave, because I believe they found the information out later, likely when it hit the media, and that's when they themselves took action. Because I would hope anyway that they tried to verify employment before they granted him a license.
Well, I think the best place to kind of wind up is to go back to where we began the conversation, which is we didn't gather up because this is just a sexy, crazy story that's a 1 in a million. Dr. Death was an intriguing true crime story, but not a 1 in a million. And so we don't want to scare people. We never want to scare people from going to the doctor. We all are patients. We all need to go to the doctor. We're here because we're trying to improve the healthcare system. But I think what we want people to know is that these are not isolated cases. These are patterns. And so not every case gets a national headline, like a Dr. Death or like a bingo doctor, but the patterns are the same and the solutions are not difficult. The solutions have been known for decades, but what we have is not a lack of how can we fix it? It's a lack of who wants to fix it. And, what I say is it boils down to a political problem, not a political problem in terms of it's a Republican issue, it's a Democrat issue, it's a red, it's a blue, liberal, conservative. It is that we want to educate the public so that because the public are all patients. We want to educate politicians that 100% of their constituents are patients. We want to educate politicians to remind them they are not exempt from being on undergoing a 10-minute cataract procedure and not coming out alive. It could happen to any of us. None of us are exempt. Again, not to scare people, but we need constituents to make politicians aware that these issues matter deeply to them and their families. And then people need to start voting based upon what politicians are going to take patient safety reforms seriously. That's my 2 cents. If anybody else wants to pitch in, please feel free. That's where we're all in this together. And as my dad used to say, none of us are getting out of here alive. So we all have a vested interest in making it safer for all of us, our fellow citizen, our fellow patient. So, well, as we were talking briefly before we came on to record, Bob Oshel was telling us about a dancing doctor from Georgia. So I think we should probably get together again next time and talk about the dancing doctor, if you all would be willing.
Sure.
And
Have to change shoes.
exactly.
Yeah, not the shoes are not the problem. The problem is you've got the dancing doctor, you've got the bingo doctor. These cases keep coming up, and there needs to be a change in the safety culture in facilities, as well as a change in the law to close the loopholes, make sure that the licensing boards do what they're supposed to do to protect the public, but make sure the public can get the information they need to protect themselves as well.
Well,
Unfortunately, in my opinion, until the law changes, the culture won't change.
right.
And it's very difficult to get the law changed.
Of course.
I mean, if paying my taxes was optional and there weren't going to be any penalties if I didn't pay them, I probably wouldn't. If it was just on me to do the right thing, and that's probably not a great example, but we've had way too much leniency giving physicians and hospitals special treatment and letting them self-regulate themselves. And
It's not just physicians and hospitals, it's all the professions. The lawyers, the architects, whatever, they tend to be self-regulatory by, allowed to do that by the states. So it's
it's
just
the
more of a matter of life and death with physicians than with lawyers.
yeah,
it's the old-fashioned guild.
Mhm.
You broke
Let's-
up.
Band together and protect their own.
Circle the wagons.
yeah, exactly. Well, thank you all so much for coming on and talking today. And stay safe, stay warm. We'll talk soon.
Take care. Bye.